Hello, my name is Crystal Dahl, and I am the Online Communications Manager here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar, How the Trump Administration is Changing U.S. Immigration, a 6-month look back. For those of you new to Meritas, Meritas is an established global alliance of closely connected yet independent law firms that each offer a full range of high-quality, specialized legal services. We were built upon a rigorous system for monitoring and enhancing the quality of our member firms and have been connecting clients with carefully qualified business legal expertise in 240 markets around the world since 1990. Meritas Capability webinars are regularly presented by Meritas members. Before we get started, I'd like to quickly go over a few housekeeping items. Meritas now offers the ability to listen to our webinars through your computer speakers. If at any time you have any difficulty hearing the presentation, you may call into the associated telephone line instead. All phone lines will be muted. If you experience any technical difficulties, please press *0 at any time to connect with a support technician. Since you will be muted, if you have a question, please ask via the chat feature found on the left-hand side of your screen. Joel plans to answer questions at the end of the presentation. Lastly, in the next few days, I will distribute a copy of the presentation, a recording of the webinar, as well as Joel's contact details. Our presenter today, Joel Pfeffer, is a partner of our Pittsburgh, Pennsylvania Meritas member firm, Meyer, Unkevic & Scott. He is chair of the Corporate and Business Law Group, a member of the International and Immigration Law Group, and is a member of the firm's management committee. Mr. Pfeffer works primarily in the areas of immigration, nationality, and corporate law. With that, Joel, are you ready to get started?
I am.
All right.
Hello, everybody. This is Joel. Okay, thank you. Hello, everybody. This is Joel, and I'm going to talk for about half an hour on how the Trump administration is changing U.S. immigration, and after that, we'll take any questions on the chat line. The three topics I'm going to address here are travel to the United States, initiatives that affect U.S. businesses and business travelers, and several predictions of what I believe lies ahead. Before I address these three topics, which are essentially business-related topics, let me say a word about the area where the Trump administration is making its most significant impact, and that is the area of deportations. Under the Obama administration, the policy was that deportations would be, there would be a priority of deportation for people with criminal records. The Trump administration is taking a different approach. It's sort of called the fear approach. And they are arresting and refusing to bond people who have no prior criminal records but are illegal in the United States. In fact, Immigration and Customs Enforcement, known as ICE, the director, Thomas Homan, has been quoted to say that it is important to arrest non-criminals and to send the message that it's not okay to stay in the United States until you break another law. In other words, prior to this, the illegal community felt that it was okay to stay here, not technically okay, but practically okay to stay here unless you otherwise ran into the police. And the Trump administration is saying, no, we're not going to tolerate that. Just to give you a bit of an example, it's sort of an alarming example. An immigration lawyer in Philadelphia posted on a immigration lawyer's site that her client was sworn in as a United States citizen, and that allows the citizen to petition for a spouse who is out of status. As long as the spouse entered the United States legally, a U.S. citizen can apply for a green card for his or her spouse once they become a citizen. So this client became a citizen on a Friday and was prepared to file the papers for the spouse on Monday, but before they got to it, the ICE came and arrested the spouse. So that's sort of a frightening thing because it is apparent, or at least believed, that the government got its knowledge of this illegal person from the citizenship application that was completed on the Friday before the arrest. So that's just an example of what we're seeing in the field, and this is probably the area where the change in policy is making the most significant impact, and frankly, it's the area where most immigration lawyers get the most questions. Most of those questions are difficult to answer because there's not much you can do for somebody who's here, who's overstayed their period of admission in the United States, unless there's a close relative or the potential for an asylum claim. But basically, there are not that many avenues of remedy for these people. Now, turning to the business immigration issues that I'm going to address here today, let's start with travel to the United States. The first thing that the President did when he became President was publish 3 executive orders on immigration. Most of them were basically policy statements. But one of the executive orders prohibited admission of any foreign national from countries known as the, quote, countries of concern, Libya, Syria, Iraq, Iran, Sudan, Yemen, and Somalia. Now, the reason Iraq is underlined there because in March Iraq was removed from the list. Now, the problem that developed from the publication of these executive orders is that there were no clear guidelines. Whoever decided to do this didn't really think it through, and there were people who were traveling to the United States when the executive orders were released and became effective. It was unclear whether if you had dual citizenship, you were the citizen of another country. You just happened to be a citizen of one of these countries. Does it affect you? Does it affect you if you have a green card? Does it affect you if you have U.S. citizenship? So all of these were questions that the government itself was surprised by because immigration officers at ports of entry could not answer them. So it became very confusing and very difficult, and it created significant hardship to travelers. Shortly thereafter, within a couple of days, the courts issued injunctions and restraining orders against the implementation of what's been called the travel ban. And all of that was basically solved for the meantime. I just want to point out here that the countries of concern that are on this list are countries that were earmarked as concern by Congress in the Obama administration in a matter related to visa waiver. Visa waiver is a program where if you're citizens of, I think, 38 countries, mostly Western Europe and other similar countries, Australia, Japan, there's some countries in South America that are subject to visa waiver. The citizens of those countries do not need to apply for visas. A visa is a document issued by a U.S. consular officer allowing the holder to make application for admission to the United States and come to a port of entry. The visa is necessary for you to board the airplane. Citizens of those 38 countries do not need to make visa application. They can come in on what's colloquially been termed ESTA, because ESTA is a system where you have to register. In any event, Congress passed a law in 2015, I believe, that said that if you had visited one of these countries within the last, I don't remember what the period of time was, but the last 5 years, I believe, you had to make a visa application. So those countries became countries of concern, and the Trump administration singled those out. Now, on March 6th, a new executive order was issued that removed Iraq from the list of banned countries, and the order was to take it basically dealt with all the questions that I mentioned earlier, all of the doubts about what if you have dual citizenship, and what happens if you already have a visa, and what happens if you are a green card holder, and all those questions. And it basically excluded people who were in any of those categories that I mentioned, or people who were in the United States already who were, it doesn't affect them. Okay, subsequent thereto, shortly after that, the court enjoined the application of the travel and visa ban, and the Fourth and Ninth Circuits have upheld the injunction on the travel and visa ban, and the Trump administration has a petition for certiorari pending that would seek to overrule the appeals courts and I guess assume would send the matter back to the trial courts for further instruction. The status of that is that the final briefs on that Supreme Court petition were due yesterday, and it is expected that the Supreme Court will decide tomorrow whether or not to accept this case. And if they accept this case, there will be a briefing schedule and followed by an argument schedule in the next term that will begin in October. Okay. Now, oh wait, did I skip I skipped the slide? Sorry about that. Okay, now the presidential memorandum issued on March the 6th calls for enhanced vetting procedures and vigorous enforcement of the grounds for inadmissibility. Several of things have happened, some before this and some after this. But let me just introduce this by saying that there are not that many really the statements have not turned into effective measures that have prevented that many people from coming to the United States. So what I'm going to explain here is what little has happened, and that all of this is speculative, but it can be expected that these tools that have been put in place can be used by the administration to further restrict immigration or travel to the United States. I should also add that although the presidential order, the executive order of March the 6th removes Iraq from the list, citizens of Iraq are still subject to thorough review and scrutiny. And we have here in the Office of Cases somebody who is in the process of adjusting to status in the United States and is from Iraq. And the executive order doesn't technically cover this person, but we're seeing a very long delay in their case. Now, getting to what has happened in the vetting procedures and rigorous enforcement, the Customs and Border Protection, the CBP, the people that govern the border at the airports, etc., they have announced that they have searched nearly 15,000 electronic devices from October 1st to March 30th, 2017, and they have published a procedure by which they are outlining the process of somebody whose device will be subject to inspection. Now, typically, that would be used in a case where somebody is on their lookout list or has a name that matches somebody on their lookout list. So the name is a person of interest to them, and the procedure provides that the device is retained by the Customs and Border Protection, and the CBP lets you know when they're ready to give it back to you. So they're basically in control of that process, and the advisory also says that they have the right to keep whatever they want. More importantly, though, are visa interviews at U.S. embassies. Again, as I said earlier, in order to come to the United States, most citizens of countries other than the 38, require visas to enter as visitors, and everybody requires a visa to enter in a category that permits employment. And the U.S. embassies have been instructed to identify applicants and population groups for additional screening. Now, the State Department has ordered the consulates to undertake mandatory social media checks for all applicants who have been present in territory controlled by the Islamic State. Now, there are no reports of that really going on much. It's rarely done. And the same is true, they've published this DS 5535 supplement, which is discretionary. The consular interviewer can ask for completion of this supplement, which requires a 15-year history of travel, employment, residence, and the names, dates of birth, and places of birth of all siblings and children. So that's another tool in their toolbox of sorting people out. And frankly, what will happen for most people is that it will cause delays in processing. Another tool in their toolbox is something called EVIS, the Electronic Visa Update System. There are countries, the duration of a visa, of a visitor visa, depends on something called the reciprocity schedule, or the reciprocity between the United States and the passport holder's country. So for example, if you're a citizen of Mexico, there are certain visas that you can only get for 1 year, whereas if you're a citizen of China, you can get them for longer. Or if you're a citizen of the UK, you can get them for longer. So several years ago, the government instituted a system of electronic visa updates, so that even if you have a visa, for example, the practical example would be China, because at the moment that's the only country that it applies to. If you have a 10-year visitor visa from China, periodically or every 2 years, the visa holder has to go online and answer questions, update their information. And if they don't do it, the visa is canceled. If the visa is canceled and the holder tries to use it, they will have a very unfortunate situation where they will try to get to the United States and be turned away at the airport. But at the moment, China is the only country. I would expect that other countries will be added to this list once the government sort of gets the idea that they can do this. Interestingly, the EVIS questionnaire now contains an optional question asking for your social media identifier or your handle. So that's another thing that we could see in the future, that that would be part of the general questions related to a visa. The administration has now received approximately $1.5 billion in requested appropriation for border security and interior enforcement. What you're going to see, I think, is increased enforcement in places where the government has traditionally been quiet, places in the interior of the country, places that are industries that are not industries that are normally connected with the hiring of illegal aliens. I think that, if the government wants 10,000 immigration officers, they're going to need to do something. So I think we're going to see increased enforcement in places where we've not seen it before. Now, another program that the government has from time to time tried to implement without success is the biometric entry-exit tracking system for foreign travelers. They have been successful in implementing a program of entry for foreign nationals, but exit has been a problem for them, and they've not been able to get their hands around how to get biometric documentation of people leaving the country so they can know who is here illegally and who is not. At the moment, most of that is tracked by airline manifest records. The airlines submit their records to the Department of Homeland Security, and people are sort of checked off the list. And frankly, you can see everybody, all foreign nationals who come to the United States on temporary visas need something called an I-94 card, which means that there's a record. It used to be a paper record, but now it's an electronic record. They don't give out the paper anymore. The person admitted must go onto a website and print their record. And you can see in that website departures, entries and departures, and most of the time they're pretty accurate. Now, the government did announce on June the 2nd that it is deploying a biometric exit technology at Dulles Airport for one flight, I believe it's to Dubai. So the government is getting on board with this program. I believe that in Atlanta there's another program for departure biometric exit for a particular flight or country, and I think we're going to see more of this for foreign nationals in the future. Okay, the International Entrepreneur Rule. The International Entrepreneur Rule was a rule that became effective shortly at the very end of the Obama administration. I think it was on January 17th. the Department of Homeland Security published a rule that was supposed to be effective, I believe, on July 17th, that would allow entrepreneurs who have raised a significant amount of capital from investors who have a track record of investing in successful companies to remain in the United States to build their startup companies for periods of 3 years with a possible renewal of another 3 years. Now, just by way of background, the Department of Homeland Security cannot create a visa classification for people like this. That requires an act of Congress. But what they can do is decide that we will allow people to stay or, quote, parole, which is another concept in immigration law, parole them into the country for a temporary period for a temporary purpose. Parole is normally used for humanitarian purposes, where somebody needs medical treatment and the government will issue a parole. But here the Department of Homeland Security announced that it would admit or allow to stay entrepreneurs under certain conditions. The Trump administration has announced recently that they are not going to implement this rule, and they're sending it back to the Office of Management and Budget for further review. This is not unusual when a new administration comes in and they want to implement their policies, and this is sort of this kind of rule. It sort of cuts between jobs for Americans and foreign investment. So it's not. I think the administration really hasn't decided where it stands on something like this. So it's sending it back to OMB for further review. The government has decided to have one of the executive orders announces a Buy American and Hire American policy. This directs federal agencies to propose reforms to the H1B program to prevent displacement of American workers. Now, the H1B program is or it was at one time, the core program that allowed for professionals to come to the United States. It still is. The problem is there are way more professionals who want to come to the United States on a temporary basis that this program allows than there are slots available. There are currently 85,000 slots available every year. They become available on October 1st. Application must be made on April 1st, and the first week in April has over the last several years traditionally been a lottery where the winners are announced several weeks later who got the 85,000 slots. This is a program for employment-sponsored aliens. In other words, an employer must sponsor employment of a foreign national in a professional position. The foreign national must have a professional degree, and the employer must be paying what's called the prevailing wage. That's basically the H-1B program. The President has directed the agencies to take a careful look at the H-1B program. The Labor Department has announced that it is going to increase protections of American workers and more aggressively confront entities committing visa fraud, visa program fraud and abuse. They have decided that the department will enforce vigorously all laws within its jurisdiction. So they have announced that the Wage and Hour Division will use all tools in conducting civil investigations to enforce labor protections provided by the visa programs. Well, one of those visa programs is the H-1B program. So I think we can see the Department of Labor scrutinizing the labor condition applications. Those are the pre-filing applications that are made with the Labor Department that attest to the fact that the company is paying the prevailing wage. So those are simply filings or attestations. The company swears on these papers that they are going to pay the prevailing wage. They're not going to pay them less than the American in the street is paid for this job. They're not going to pay less than the American in their company is paid for this job. And the Wage and Hour Division is instructed to take a careful look at this program. The employment and training, take a careful look at how, I'm assuming what's happening here is take a careful look at whether these people are being paid the prevailing wage. The Employment and Training Administration that runs the program is charged with developing proposed changes to the labor certification application, which is the application that the attestation about actually paying that prevailing wage. One of the other things I wanted to point out was that the Trump administration had announced that one of the initiatives here was to combat unfair visa rules that harm American workers. If you're familiar with the H1B program, the prevailing wage is typically determined by the public statistics on the Department of Labor website, which are divided into 4 categories: level 1 wage, level 2 wage, level 3 wage, and level 4 wage. So the Trump administration announces that H-1B's visas are supposed to bring the highest skilled and paid labor to the United States, but according to studies, 80% of the approved applications were for the 2 lowest wage levels allowed. So one of my predictions is that the government is going to require H-1Bs to have the government pick the level that you can pay. The prevailing wage has to be picked by the government, not by you. Right now, the company that employs this H-1B can decide which level they are at: entry, second, third, or fourth. In the green card program, you can't do that. The government does it. But in the H-1B program, the employer can do it. Now, the reason that they're at least the lowest 2 wages are typically used is because many of these people are entry-level employees, and it's justified. But there are situations where employers use lower wages than they perhaps should, and you would think that if there's going to be let me skip to that slide. If there's going to be a thorough review of the H-1B program, one of the things that they're probably going to review is how the prevailing wages are determined. Let me go back to my other predictions here. Okay, I-9 compliance audits. I think the additional inspection officials, the additional officers that are going to be hired by DHS will increase the number of I-9 compliance audits by DHS, including unannounced inspections in target industries such as hospitality, farming, and food production. I-9 is the tool that the employer uses to determine whether or not the new employee is qualified, is authorized to work in the United States. So I think we're going to see more inspections here. E-Verify. In prior administrations, particularly in the Bush administration, the White House was very interested in making E-Verify mandatory. E-Verify is a web-based program by which employers who voluntarily, or at least have their arms twisted to sign up for it, have to input the name and other identifiers about new employees and get approval from the web-based system that the new employee is authorized to work in the United States. It is mandatory right now for employers with government contracts, but it's not mandatory for everybody. And the Bush administration really wanted to make it mandatory for everybody, but the Democrats were holding out for some kind of amnesty program in return, and it never happened. I would think that if the Trump administration is serious about this, they will take a good hard look at making E-Verify mandatory. I went through this one already. And finally, colleges and universities admit many foreign students to the United States. They are required to issue some form called an I-20, confirming admission. It's all tracked by a web-based system, and I think that we're going to see closer scrutiny of colleges and universities and their use of the CFIS system. Right now, CFIS has introduced a program. CFIS is administered by Immigration Customs Enforcement. The schools each school is assigned an officer who is supposed to work with them closely to be sure that everything is okay with their record keeping and tracking and how the schools input the information into SEVIS. So I think we can expect closer scrutiny if you represent a college or university or school. I think we're going to see closer scrutiny of that, and particularly we're going to see more careful scrutiny of applications abroad that for students seeking to come to the United States. Okay, that sort of concludes my presentation, and if there are questions, I'd be happy to take them. I do have a question here. Which consular posts do you see becoming most problematic for visa issuance in the next 12 months? Those consular posts are the ones that are busy right now that are problematic. China and India. Applications for visas in China and India are often delayed and often denied. The Philippines, Singapore, those parts of the world will likely experience increased problems, increased scrutinies, and increased delays in visa processing. Okay. Do you see the Trump administration using export controls as a way of controlling immigration? Let me answer that with a little background. The export controls are laws that prevent imparting or making available information that you cannot, if you have technology, or sometimes it's dual-use technology, it can be used in military, it can be used in civilian, you have that technology, you may not export it. Giving it to certain countries, certain technologies can't be exported to certain countries. To allow a foreign national from one of those countries to have export that knowledge is a violation of these laws. And now the petitions that are filed with the Immigration Service require a sign-off that the employee will not have knowledge that is subject to export controls. And the other place where it practically applies is when someone applies for a visa abroad, the consular officer is supposed to make a determination whether the employment is somehow related to something called the Critical Fields List, which is a list last made public in 2002, which lists problematic employment. It includes anything from engineering to nuclear physics, and many people get subject to this and have to wait abroad for clearance, typically 30 days or so, and it's a delay problem. I don't see the government doing any more than this, requiring employers to sign off that there are no export control issues, and actually, if you have need for representation or consultation on that, there's a Meritos attorney, Brian Walsh, who is an expert in that, and he'll be happy to provide consultation on that. And delays at the consulate, well, delays at the consulates will continue under what's called administrative processing, which is sort of a mysterious kind of, nobody really knows what they do, but it does take time if a consular officer decides that there is a problem with export control or a potential problem with export control in the field that this person is engaged in. Any other questions? Well, I have no more predictions. Okay.
It looks like, Joel, that David had a couple questions about just what is OMB and ETA and WHD.
Okay. OMB is the Office of Management Budget. Are those questions on my screen? Or are you giving to me?
Yeah, they're
or am I missing
chat.
something on my screen? Well, I don't see the chat. How do I get to see that?
Did you make
How do you
your
let me in the
screen
chat?
large? So if you hover over the large slide, can you minimize that?
Yes.
Exit full screen down on your bottom. Like, is that available to you?
I don't see it.
No.
Add
Well,
slides?
that's okay.
No.
I'm happy.
Why don't you read me the questions? I can tell you what OMB is. OMB is Office of Management and Budget. They are the people that have to approve every regulation that is published by the government. They are an arm, I believe they're an arm of Congress, and they have a say in every regulation that is published by the government. So I'm not familiar with the procedure whereby the administration sends the regulation was promulgated for effective date July 17th. Apparently the procedure for the first step in the procedure to rescind the regulation is to send it back to OMB. That's my guess. I don't know the answer to what OMB does with this, but I'm assuming that the first step in rescinding a regulation is to send it back to OMB and explain to OMB what your problem is with it. ETA is the Employment Training Administration of the Department of Labor. They oversee all of the programs that are immigration related. So when an employer has to show that what the prevailing wage is, or the employer has to file any kind of attestation that's related to the Department of Labor, they're sort of partners in this immigration process. It's the Employment Training Administration that has jurisdiction over that. That's an arm of the Labor Department. Another arm of the Labor Department is a Wage and Hour Division. They monitor typically whether the employers are paying sufficient salary to, for example, non-professional employees, and they typically audit employers' payrolls to be sure that. And what apparently is happening here is they've been given the directive to pay close attention to how foreign nationals are paid and whether or not they are being paid the prevailing wage that is required under the H1B program. Crystal, any more questions?
That is all I see right now. Well, do you want to wait a second, or do you want to just, I can pass on your contact details as well. So if anything
Okay, if anybody has any questions, feel free to email me. No problem.
Okay, all right.
Okay, it's a pleasure talking to you,
Joel.
and thank you for listening. Yes?
Yeah, that was great. Just a reminder to everybody, I will distribute a follow-up email to everybody who's registered that will include Joel's contact details, a copy of this presentation, as well as a recording if you'd like to listen to it again or pass it on to somebody else who might find it of interest. So thank you for joining us, and we hope everybody has a great day. Thank you, Joel.
Thank you. Bye-bye.
Yep, bye-bye.